Number 17, Your Honor, Hall and Hall.
Okay.
We would send it over 2 weeks. The parties have been discussing an agreed parenting plan. I might be able to get it resolved in a fairly full form. So I believe we agree to set over 2 weeks in hopes we'll be able to accomplish that this week.
Any objection, Ms. Gilmore or Ms. Height?
No, Your Honor, and I would just like to note that if we aren't successful in reaching an agreement, I would still like to address the support issues at the next hearing as well as the parenting plan.
Okay. And I'm sorry, Mr. Baldwin, did you say 2 weeks?
Yes, Your Honor.
I'm going to be in trial in 2 weeks, just so I don't know if it needs to be in front of me, but if it does, it would need to be 3 weeks.
Is Your Honor trial next week or no?
Not until Wednesday.
Okay.
So
I thought you
I
were in
will be
trial
here
next
next
Tuesday.
week.
Okay.
No,
next
it's
week if that works.
28th through the 31st. I'm in trial.
Okay.
So, Ms. Gilmore, do you want 1 or 3?
Do 1.
Okay, so we'll set this over Hall and Hall 23-3, 2508 to the 21st at 1.
I thought it would be relatively short, but I didn't want to jump in just in case it isn't.
All right. Yes, I have parenting plans that have been provided by both parties. We're looking at temporary family law order, parenting plan, and child support.
Correct.
So I guess I'll give you each party a minute or two if there's any additional information you have. Otherwise, I'm ready to just make a ruling.
Okay, I can just note for the court that I did receive an email from Mr. Klopp, and I don't want to speak on his behalf, so he can confirm if I'm incorrect. But the email that I received from him indicated that he was agreeable to the majority of the holidays, with the main points of contention obviously still being summer, spring break, Thanksgiving, Christmas, and the child's birthday. Your Honor's well prepared for purposes of today's hearing, so I won't belabor the point. However, I would just note, and Your Honor likely saw in the most recent declaration, there's been some conflicts with transportation. Therefore, my client's request that a neutral location site of either the Castle Rock Police Department or the Park and Ride be utilized at this time, just given those conflicts between my client and the girlfriend of Mr. Klopp. But otherwise, I'll defer to the court if you've already reviewed all of the pleadings. I won't belabor it any further.
All right, thank you. Mr. Klopp, any comments?
Yes. Yes, she is correct with the spring break, winter break, summer, and Brody's birthday, and then also the transportation. That I disagree with. I don't think that we should change up what we have going, other than to change it to pick up after school on days that he does go to school. And then to pick up at 7 p.m. at each other's houses. The only issues that we have been having have been caused by Lacey, overstepping boundaries and disrespecting our privacy. So if she could just remain in her truck, I feel like those issues could go away. Just like yesterday, everything was fine because she remained in her truck and she respected my privacy, and everything was fine. So that I feel like that could be avoided if she just would respect our privacy.
You were asking for a different pickup and drop off time.
Yes.
I think you said 7 and she was suggesting 6. Is that correct?
Yes. Yes, Your Honor.
Okay. And is 6 a problem with your work schedule or anything of that nature, or?
No, just our family dinners and stuff. It just seems like I get off work at 5 p.m. and by the time I'd either pick Brody up or my other children, it's almost like 5:30 already. And then if we have dinner already at home, it just doesn't really give us a whole lot of time to eat dinner as a family. We're kind of rushing him out the door with food in his mouth a lot of the times. So I just ask for an extra little hour, but.
All right, so here's what I'm going to do. I'm adopting and I'm working off of Miss Bliss's paperwork solely because some of the language that's in there is language I'm going to adopt. So I have a temporary family law order. I'm adopting that as proposed, which is I think the same as what Mr. Klopp proposed. In the parenting plan, joint decision making across the board. At this point, given the concern between mediation and court, I'm going to have the any dispute resolution, go to court at this point. If there's an agreement to change that later, that's great. I am going to have the exchanges every Monday. I'm going to make that 7 p.m. Or otherwise agreed upon. I am going to adopt the request as far as summer. So each each parent can have 5 days with the child during summer, and that'll to be scheduled with the other parent no later than May 15th each year. Given the child's age, I am going to adopt the spring break schedule for on a temporary basis that is proposed by mom. So half a week to each parent. Just want to make sure I hit on all the areas of contention here. There was a concern over
Thanksgiving, I think, is the next holiday on my list.
Proposal from Miss Bliss, Wednesdays. I'm going to just change from 6 p.m. to Wednesday after school to Friday at 9 a.m.
Was that for Thanksgiving, Your Honor?
Yes.
Okay, thank you.
For winter break, or Christmas break, I'm going to change. I'm going to change what's been put forward. I think exchanging on the 23rd, the 24th, the 24th, and the 25th. I think that's just a lot of exchanges for a young guy. So I'm going to change that to even years to the father from date school is out to noon on Christmas Day, with mother from then until school resumes. Odd years would be the opposite. What I do foresee is that may impact the week on, week off schedule somewhat. So if that resets it and somebody gets a day or two extra time, I think that's something that we just need to understand may occur, and hopefully it won't become an issue. And then the last one is the child's birthday. And I'm going to adopt the recommendation of Miss Bliss at this point. So father will have him 8 to 4, mother will have him 4 to 8 the following day, and then that'll reverse. So each party will get an opportunity to be with him on his birthday. For transportation arrangements at school, this should go without saying, but any outside influences on exchanges, any non-parent involvement in exchanges should be courteous, kind, respectful of the young person that's present, and respectful of the other parent that's there. So exchanges will be at school, and or the home of the party. I'm not going to do the park and ride at this point.
So, Your Honor, my only concern with that is Mr. Klopp's girlfriend has just recently sought a protection order, which obviously would prohibit my client from going to her home, which she also shares with Mr. Klopp. So assuming that goes forward, I mean, I don't know what her intentions are, if she plans on dismissing it or moving forward, but assuming if that moves forward and for whatever reason is granted, then obviously that would impair the ability to have the exchanges at the home of Mr. Klopp.
Well, that does throw a wrench into it. So I will revert back then to the park and ride, and that's the Castle Rock Park and Ride. Is that correct?
That is what I have in there. Yes, Your Honor.
Sorry, I already whited it out.
Your Honor, can I say something on that?
If there's an active no contact order, then I can't do anything about that. That was your girlfriend's choice to file that. That protects your home, and she can't come within a certain distance of your home unless that order's gone. So Castle Rock Park and Ride it is, or the school.
Okay, thank you.
I don't believe there were really any other issues with the remainder of that, so I'll sign that order.
What about child support, Your Honor, or were you just?
I'm getting to that right
Oh,
now.
okay. Thank you.
So, obviously, this is the area where there was the most disparity. There was a significant difference in the petitioner's wages, depending on whose worksheet you looked at. As far as the order, what I didn't see, Miss Bliss, was any kind of deviation as far as for essentially a 50-50 schedule. And I indicated, or you indicated, that no party asked for that. And I think in the initial response, there was a request for a deviation for the parenting time. So I guess if either party wants to make any comments regarding that,
I'd be happy to, Your Honor. Obviously, it's my client's position that Mr. earns a substantially higher wage than she does. As Your Honor is aware from my client's declaration, she has been diagnosed with fibromyalgia, is incapable of working full-time wages. She does have a job where she's working $30 per hour, but it's only at 26 hours per week. So I think that's the largest contention with our worksheets is Mr. Klopp has indicated that she should be imputed at 40 hours. Obviously, there's nothing to reference, and even in his declaration supports that historically she's never worked full-time wages. So it's our contention that my worksheets are appropriate. As for deviation, when the court is determining whether or not to apply a residential credit, you have to look at the incomes of both parties, the homes of both parties. My client provides for the court that without some child support, that she doesn't have sufficient funds to support this child. As Your Honor can see from the child support worksheets, he earns drastically higher wages than she does. He did provide a budget, I saw in his responsive declaration, but it doesn't take into consideration his girlfriend's income, which he acknowledges she lives with him, assists with the bills and the paying of the rent and utilities and the like. So at this time, we're asking the court not to order a deviation. If Your Honor is inclined to order a deviation, I don't believe a zero transfer payment is appropriate in this case, just given the incomes of the parties. So depending on what Your Honor decides to do with that ruling, I can rerun a deviation or prepare another order.
Can I respond to that, Your Honor?
yes.
Okay, to start with, Lacey has worked full-time in the past. She was working at Happy Kids Dentistry when we first got divorced. I supported her until she got that job financially and fully. And then she has had a few other jobs in between since Happy Kids, to Jamie's, and some other jobs. And then if she is fully disabled for that, how come she hasn't provided any paperwork for being disabled? I feel like that should be provided if she's fully, oh my goodness, oh, disabled. The Brooke, she does work, but she only works maybe one day a week, not even. Sometimes she only works once a month. Sometimes it's once a week. Sometimes it's once, twice a week. She goes to school full time for nursing school, which is super expensive. Lacey fails to mention that she has a working boyfriend from home too as well. So I think if we're going to consider Lacey's income, I believe that we should consider Lacey's boyfriend's income as well, who lives there full time. And then I also have a 7-month-old daughter that I take care of full time too. Financially.
All right. So here's what I'm going to do. I am going to order at this point that there be a transfer payment given the circumstances. I am going to deviate from the calculation. Both calculations. I think there was one party landed at 824, one party landed at 879, something like that, without the deviation. And then I think Mr. Klopp's suggestion with the deviation would be a minimal transfer of, I don't know, $100 or so a month. This is this is child support. This isn't spousal support. I'm gonna, and I think we were sitting at $300 a month. Was that what the previous amount was?
Yes, ma'am.
All right.
Was it 300? Okay.
I'm gonna set support, in this, temporary order at $500 a month, and that'll, I'm gonna have that start March instead of February.
Were you just gonna interlineate that on my order,
Yes.
or did you want me to compare new? Okay.
I won't enter the worksheet, but I'll enter the support order based on that.
Did you say you weren't going to enter my worksheet? Sorry, I just want to make sure.
Yes, correct. Just
Okay, did you want me
just
to
the order.
prepare?
If
Did
you want
me
to prepare,
new worksheets?
please, and then I will happily sign those ex parte and enter them to, or send them to the clerks.
Were you adopting either one of our incomes for the other party, just so I know which numbers to put in where? Or do you want to adopt my worksheets and then I can prepare a deviation and submit
Sure,
that?
let's do it that way. That'll probably be the
Okay.
easiest.
Okay, I can do that.
All right, good luck. Thank you. We're
you,
here
Judge.
for presentation of the parenting plan, which was filed March 3rd, 2023. All right, Casey Bowen. If you
Oh,
want-
yeah, I'm here.
Okay. Did you receive a copy of that parenting plan?
I did not receive a parenting plan of that.
Your Honor, if I may, I did. I emailed it to her. I spoke to her on the phone. She stated that she did not agree with it. And I
Oh,
said,
okay.
then I will set the presentation and we'll come in.
So I'm going to ask you again, Ms. Bowen, did you get a copy?
I
of
did,
the
yes.
parenting-
Yeah, I did receive that one, yes.
And I don't have, looks like you're not represented at this point. You haven't filed any objections to that parenting plan.
I did. I filed a parenting plan. I think it was on, I don't know the exact date. I responded back to the parenting plan. I emailed her. Let's see.
I received no objections, Your Honor. I received a response to the petition, so we can strike the default, obviously. And I received a proposed parenting plan of her own that wasn't based on the hearing, was just a proposed parenting plan. And that's what I received.
So Ms. Bowen, did you file anything?
I did file something. I filed something and I sent a proposed parenting plan back to her on the 3rd, on March 3rd. I filed everything.
So you-
And then I also asked for my visitations because I haven't been getting my visitations, and I finally got a response last week to see my children, Allie and Nolan, tomorrow at 2:30 to 4:30.
And
at
Your
the
Honor,
parent-
if I may, we've kind of had a hiccup in this as well. CPS just took Miss Bowen's other children the other day.
That's complete confidentiality for my other children. That's nothing to do with Ellie and Nolan. I have not seen them since December. I've missed them.
Okay, Ms. Bowen, I'm going to ask you to not interrupt people continuously. So go ahead, Ms. Winkles.
Yes, apparently the police found Miss Bowen intoxicated, took her other children. CPS was going to place them with my client. There was a hearing in the dependency court. Her children were placed with her dad, Troy Bowen. So my client was advised by CPS to not do anything until such time as this court had heard, because obviously there's an active dependency with the other children now as well. And so there is supervised visitation coming up, as Ms. Bowen stated, but there is obviously CPS is involved, as is the dependency court for her other children.
Right. And Madam Clerk, I don't see anything filed in this case since March 7th. I'm assuming all scanning has been done for today's docket, assuming it was filed, would have been filed back on the 3rd.
That's correct, Your Honor.
Okay. All right. Well, based on everything, I think there's, we've had several hearings where Ms. Bowen wasn't present. She was previously represented. And so we had hearings where her previous counsel was present. I have reviewed the parenting plan. I have not seen any objections, and there's nothing that's been filed for me to see at this point. So I'm going to adopt the parenting plan that's proposed. That obviously can be revisited. It's a temporary parenting plan. But given the circumstances, I will sign that once I receive it, Ms. Winkles.
Thank you, Your Honor.
So does that mean I get to still see the kids tomorrow?
I have no reason to think that you still won't have visitation tomorrow. So that, yes,
Okay.
that should still happen.
Yes.
Okay.
Your Honor.
Okay.
Thank you.
Your Honor, Your Honor,
Oh,
and guardian ad litem here. I see that this is also on for compliance of the guardian ad litem. I have not received any intake materials back from Ms. Bowen. I've received from Mr. Mansker. I need to receive payment and intake materials back. So I wonder if you could encourage that today.
So Ms. Bowen, have you received the intake packet from the guardian ad litem?
I have not. No, I did email her last court date of my information. But I have not received anything from her.
My records show, Your Honor, that was mailed out on March 2nd to the address that I have on file. Correct.
Huh. I didn't receive anything. Okay, I will look again.
All right. Well, if Ms. Bowen, if you'd be so kind as to reach out to Ms. Height after you look to see if you still don't have anything, touch base with her about how to get that packet and get the information back to her and about payment so we can get this process going. If you don't participate in that, then that just slows everything down and makes it essentially longer until we can get some resolution in this case.
Okay.
All right. Thank you very much.
So the last
you, Your
four
Honor.
I have
you,
are
Your Honor.
44565.
Okay. That is not what I have in here. And I have to just note for the record, I'm being very cautious because we've been Zoom bombed a significant number of times recently. And so I've asked everyone in the waiting room to identify themselves by name or the case that they're here for.
Your Honor, I was wondering if I could comment.
Sure.
Kent Lakey is my former client, and when I saw that he was on the docket and not here, I had my staff call. He's apparently trying to get on and is unable to do so.
Well, I wonder if he's in the waiting
A
room.
message for him to call counsel if Your Honor wants me to do that. Or
Well, if let's let these folks in and see, and then hope for the best. Do we have a Kenton Lakey?
Yeah.
I don't know what that was. So Mr. Lakey, we just called your case. We're on for review to see if the domestic violence evaluation was completed by January 27th. And is there anything else we're reviewing today, Mr. Sanders?
So, Your Honor, just a brief little bit of history. The court ordered reunification counseling with both children quite some time ago. We filed a motion for default or compliance in August of 2022. I believe it was heard in September or October. The court set a review date in December. The court then set another review date for today to see if the reunification counseling process has started and the DV evaluations have taken place. The reunification counseling is in the early stages. My understanding from my client is there's been at least 3 or 4 appointments. I'm sure Mr. Lakey will speak to that.
I don't see him here anymore, so I don't know what happened, but
Oh, that's odd, Your Honor, because I see him here on my screen. He's Samsung SM.
oh, is that Mr. Lakey?
Yes.
Okay, I thought the phone number lit up when. Okay, sorry. Go ahead then.
No, you understood, Your Honor. We haven't received any compliance with the DV evaluation. That hasn't been, to our knowledge, filed with the court. And if it has been filed with the court, it hasn't been served on us. So at this point, it seems like the prudent thing to do would be to continue this cycle of review hearings. I know my client wants that DV evaluation filed with the court and available for her to review. But at this point, the reason for today's compliance hearing is to make sure things are tracking along. It does appear that things are tracking along, and I will let Mr. Lakey speak at this point.
All right, Mr. Lakey, I did mute you, or you are muted, so please unmute before you say anything. And if you could let us know if that DV evaluation was done.
There, is that better?
Yes, thank you very much.
All right. The DV is set up for this Friday. It was like 2.5 months out to get in. And I'm meeting with her this Saturday or Friday morning.
Okay,
So
so the evaluation's scheduled for this Friday morning.
Yes.
Okay,
I tried to get it sooner, but she didn't have any openings.
okay. I trust that's probably a problem everybody's having recently. Okay, so knowing that, Mr. Sanders, and knowing that the other portions are getting started, do you want to set another review date in a few weeks or a month?
Yes, Your Honor. I think that's wise at this point. Obviously, there's not strict compliance with the court's order, but if he made best efforts to comply with it, then I have a feeling the way the court's going to rule on that. I would suggest looking out maybe 6 to 8 weeks at this point. And I would also simply request, and this is obviously not something I'm going to ask the court to order necessarily, but if Mr. Lakey could communicate with our office a little bit more proactively about that, that would be greatly appreciated.
So we'll set this matter for review on May 2nd, 2023, with the hopes things are continually progressing. Mr. Lakey, if you, as Mr. Sanders suggested, if you can be, once you receive that evaluation, share it with Mr. Sanders. The hope would be that can help expedite some resolution to this and move things down the road a little bit quicker. We'll set it for May 2nd, 2023. If the evaluation comes back sooner and there's some changes that need to be made sooner, by all means, we can get it noted back up.
Okay. Also, I might mention, I didn't even know about the change today. I was in a completely different place. So as far as the courtroom and everything, nobody had notified me that there was a change in time or that there was a different person or whatever, different judge, sorry.
Oh, we just, at the end of 2022, we had a rotation in schedules. So I took over Judge Scudder's 1 o'clock domestic docket. So.
Okay.
Understandable.
Understood. Your Honor, just to clarify, is there a deadline that Mr. Lakey would need to file before any hearing? I just don't want to get, reports or compliance reports at 4:55 on Monday, the day before the hearing, if we can avoid it.
If we could have, so without putting undue pressure on the person conducting your evaluation, Mr. Lakey, if you could make sure that by April 14th, close of business, you have your evaluation to Mr. Sanders. And then if there's some reason that it can't get done that quickly, just let Mr. Sanders, just keep him in the loop. So that way he doesn't think that you're stalling or delaying anything.
Okay.
So more communication is better in this situation.
Okay, so April 14th by the close of the day?
Yes,
Is
please.
that what you said? Okay.
And that's a Friday.
Okay.
Appreciate it.
Your Honor, I believe
right.
number
Thank you. Good
18, the
luck.
matter of free versus free, should be fairly quick. Ms. Bliss and I are pretty close to agreement on this.
All right.
Both parties have submitted orders, and we're asking the court to enter our temporary family law order, temporary child support order, and the amended temporary parenting plan that was filed last week. Between Ms. Bliss and I, we've managed to work out most of the issues here. There's a couple of provisions in the parenting plan that we're going to have the court decide. The parties are agreeing to a week on, week off parenting plan. My client's proposing a midweek overnight, either Wednesday or Thursday for the parent with the off week, with pickup and drop off at school, daycare, or at the other parent's home when there's no school. These two boys are still pretty young. They're 5 and 7. Their parents have just separated, and Ms. Free is concerned that they not go 7 days without contact and close contact with each parent. Mr. Free participates as a coach and a leader in the boys' extracurricular activities, so he has pretty close interaction with them on his off week. Ms. Free is able to attend games. She doesn't attend practices or things like a scout meeting. And if she's just attending, that's much less interaction with the kids than she would have if they were to spend an overnight with her in the middle of her off week. So that's one thing that we're asking the court to order. The next area that we may or may not agree on, and I'm not entirely clear about this, Ms. Free works remotely. She's almost always available for childcare. Here, we're only asking that if a parent is going to be gone for 24 hours or more, that the other parent be given the option to provide childcare. The last issue with the parenting plan is exchanges. The parties have been exchanging in parking lots, and we're asking that exchanges take place either at school, daycare, or at the parent's home. These exchanges have been pretty uncomfortable for the kids. It really emphasizes the change in their family relationships and where their homes are. So we're asking that it either be home, school, or daycare. Oh, I'm sorry, there is one last thing. For this year only, my client is asking for a particular arrangement for the youngest child's birthday. That's Riley at the end of section 10. I believe his birthday is March 23rd, and she is asking that she be able to pick up both boys later in the evening on the 23rd so that she can have birthday morning with him the next morning before school. And then dad can pick him up after school and have birthday afternoon with him. I believe the only other difference we have is with one of the provisions in Mr. Free's proposed child support order. Our worksheets disagree about the parties' exact monthly earnings. I believe that's something that Ms. Bliss and I could work out so that we both agree to what the figures are. The parties are, they both make a good living. We're agreeing to a zero basic transfer, won't leave anybody short. We're agreeing to sharing costs for uninsured medical education and extracurricular activities. But because of this issue with childcare, we are asking that if the other parent is not going to provide childcare or be asked to provide childcare, we're asking that each parent pay for their own. And I think those are the only areas that I am aware of that we disagree on. Ms. Bliss may have something else to add to that.
All right, Ms. Bliss.
Thank you, Your Honor. And yes, Counsel, that those are the majority of the concerns I have. One that wasn't addressed and one that I saw in the most recent parenting plan proposed by Ms. Dow is she has her client named as primary custodian. There is no dispute as to this is a 50-50 week on week off schedule. I think both parties should be named joint custodians, which is included in my parenting plan. So that was the first and largest issue. Next, the parties have been separated since January 14th. So we're going on just over 2 months at this point. Parties have been operating on this 50-50 week on week off schedule. They haven't been including that Wednesday overnight visit. My client says that the parties have been conducting the exchanges amicably as contained in mom's declaration. The parties don't talk to each other. So yes, I mean, that's not uncommon in parties who've recently separated. Obviously there's emotions and tensions. It's just bound to happen. So the fact that the parties aren't talking to each other doesn't mean that there's conflict. It just means that they don't want to communicate with each other, at least in person. My client has had third parties providing for the transportation as well to reduce the amount of conflict that the boys are exposed to. So I don't believe that there's an issue there. Looking to the Wednesday night overnight, again, the parties haven't been implementing that in the last 2 months. From my client's perspective, it hasn't been an issue. These are 5 and 7-year-old boys. Yes, spending a week away from the other parent could be a long period of time. However, the parties have already been doing that. So we would just ask the court maintain status quo of keeping the week on week off schedule without an overnight on the off weeks. If the court inclined to provide any time, I would say maybe a dinner visit might be appropriate. But again, as counsel indicated, the children are engaged in several different activities, extracurriculars, Cub Scouts, and the like. So both parties have the ability to attend these functions for the kids, see them. Granted, it's not spending a lot of quality time with them, but getting to experience their sports and activities with them is arguably quality time. So we are asking the court to deny the request for the Wednesday overnight. Again, the transportation, the parties have been conducting the exchanges in the Target parking lot. Again, this has been occurring for the last 2 months. It has been going uneventful, as both parties have provided to the court, aside from some uncomfortability, which is inevitable, I think, in this stage of the litigation. So we're asking that our transportation language maintain status quo of the transportation occurring in Target parking lot, at least at this stage of litigation. I did see the request of the right of first refusal. I don't really have any objection if the parties are out overnight. I think given the stage and the tension between the parties, it's going to require a lot more communication than arguably either party really wants at this point. I'd say that might be more appropriate down the road. At this time, we're asking that it not be included. Just again, it's not what the status quo has been for the last 2 months. And again, it's going to require these parties to be in constant communication if they're away for overnight. Both parties have substantial support of my client's entire extended families in the area. I don't foresee there being any daycare expenses or anything of the like, or any reason as to why the parties need to have that right of first refusal language in there. My client doesn't really have an objection to mom's request for the birthday exchange this year. I think depending on what the court does with the Wednesday overnight, that might impact his overnight visitation on Wednesday, because it does fall on a Wednesday. So I guess I would defer to the court on that, depending on what your ruling is on the Wednesday overnight issue.
Do the do the kids have two questions, I guess, two-part question. Do they have Wednesday early release? And is number one. Number two, is Wednesday a heavy day for extracurriculars? Like, is that a Cub Scout every Wednesday or baseball every Wednesday, something like that anybody knows of?
Your Honor, I don't know about early release on Wednesdays. My client would be fine with Thursday. We could work out which day it is. And as far as the times for extracurricular activities, I don't really have a lot of information on that, although I do believe that they are midweek. Your Honor, our emphasis here is not on the relationship between the parents. It's emphasizing how the kids feel about this and what it's taking for them to get used to this. Mr. Free has absolutely not agreed to share time with Ms. Free midweek in the last 2 months. And that's been the issue between the parents. But she's concerned about how this is working out for the kids. She's hearing a lot of distress from these two little boys about not seeing their mother or not seeing their dad for 7 whole days, if that's how it works out. And once extracurricular activities are not happening, we hit summertime, we hit breaks on that, that'll impact their ability to spend time with both parents, which is why we're asking for that. I mean, that may go away in the permanent parenting plan, but for now we're asking that. I think that's really all I have to say, is that this is not about how the parents feel. This is about how the kids are feeling.
Well, my question had nothing to do with how the parents are feeling, but so here's what I'm going to do. I'm going to work off of Ms. Dow's proposed parenting plan. I've added Ms. Bliss under number 7. Custodian is Megan Free and Jamie Free jointly under custodian. Under 8B, midweek parenting plan, parenting time, I'm going to authorize, frankly, I think packing up a bag and moving for a night to return to school the next morning and having to me, that seems like a bigger disruption. However, I think Wednesday after school until 7:00 p.m. is appropriate. So if it is an early release, that's several hours to spend with the other parent in an off week. I'd obviously hope that if that coincides with a practice or something else, that the parent accommodate that. I am going to adopt the mom's request for the birthday for this year. So that'll be split. Sounds like Dad is okay with that. And I guess, Ms. Dow, did you have anything in your proposed order about right of first refusal?
Your Honor, I believe I did include if it's going to be longer than 24 hours, I believe that was included. I think that it was included under section 14 other. That was 14 paragraph 3 other.
Okay, all right. And then do you want, I guess, do the parties want me to, I'm jumping to the other order, the child support order. I'm happy to sign the child support order with the agreed 0 transfer. And it sounded like you wanted to rework the worksheet because you're close to an agreement there. Is that correct?
Your Honor, I was looking at both of our worksheets yesterday, and we have different numbers for income. And it's as much as maybe $400 a month. $300 or $400 a month. The proportionate shares are a little bit different. So I think Ms. Bliss and I, we could look at everybody's W-2s for 2022. We're pretty close to 2022. Or if somebody's got a new job, look at what they're earning now and agree on those worksheets.
Ms. Bliss, do you feel comfortable working that out with Ms. Dow and just presenting ex parte worksheet and child support order?
Yeah, I think that's fine.
Okay, so I'm gonna put these in the recycle pile here. There was only one, and I could be wrong, but I believe only one of you filed and maybe I just threw it there.
Your Honor, if you're looking for the temporary family law order, I
Yes.
think that I am the only one that submitted one of those because Ms. Bliss and I were in complete agreement there.
Okay.
Exactly.
All right, so I will sign the temporary family law order. I made the changes to Ms. Dow's parenting plan. It doesn't say amended, but that's okay. I have it. I think that's the one I made all the changes to. So I added the custodian portion. I changed the midweek parenting time and
You should make a ruling with regards to the
I guess the
transportation.
exchanges is really the only other at this point. I'm glad that the exchanges have gone well. I think I'm going to adopt the language as proposed by Ms. Dow. So when not in school, they can be exchanged at the home or another agreed location in writing in advance. A parking lot, sometimes I can see that not being the best scenario, especially given the age of these boys. So I have.
And did you adopt Ms. Gal's right of first refusal language in 14.3?
Yes.
Okay.
All right, and then I will sign the child support worksheet and orders whenever those are sent in and get those to the clerk as well. 0.
Thank you, Judge.
Thank you,
All
Judge.
right, thank you.
And just for brief history, this matter was before the court on my client's motion to modify the residential schedule. And that was before Your Honor in January. We filed it in January, and I think we were before the court roughly 2 weeks ago for entry, and the court did enter an interim parenting plan that provided my client 6 hours of visitation and appointed Ms. Turnbull as the guardian ad litem. We were before the court on presentation. I think it was last Friday or 2 Fridays ago, and I wanted to provide an update to the court. I did appear on the guardianship docket, and Commissioner Nelson sent the matter over to the 21st to get an update at what's happening at the hearing. As I indicated, CPS, Ms. Fowler did appear, and I don't know if she's still present. But she did send me a message indicating that it's still CPS's position that they have safety concerns with mother's home. So they're unwilling to recommend the child to be returned to mother. So we're kind of in this position where we do have a recent entry of a court order. However, I kind of wanted to get direction from the court on how you'd like to proceed, either by a sua sponte motion to provide custody to my client based on our underlying motion, or if I had authority to bring a motion for immediate restraining order, just so that we can have the situation where my client at least has immediate custody given the concerns between the two parents, and so that the guardianship can hopefully be dismissed as it's under a 60-day petition.
And guardianship was filed by her biological father, is that correct? Okay. Ms. Turnbull, do you have any information in this case?
Not yet. I have sent paperwork to Mr. Mendoza and have not received it back. And I have not, I've called and texted Ms. Aldrich numerous times and have not received any response. So I don't have a lot of information yet.
And so given the court's recent order, I felt uncomfortable bringing an immediate restraining order just because I understand the court's position, but given the kind of recent developments of CPS's position, as well as mother testified at this court at the original hearing that she wasn't going to be incarcerated. I think the next day she ultimately was incarcerated. I also filed the police reports with the court last week referencing why CPS became involved, because this young child couldn't wake up his mother and was taking care of his 1-year-old sibling, and that's why CPS has recently been involved, and that's why there's safety concerns. So I'm happy to bring a motion for immediate restraining order. Again, I just needed authorization from the court, or if the court's willing, based on our underlying motion, to do so now, I would ask that.
I don't know that I'm in a position to say that you can't do that. This is clearly a unique situation. I just was looking for do you know when the last finalized parenting plan was?
There actually was never a finalized parenting plan. I'll pull it right now, but it's called a residential schedule, and it was from 2017. The person that prepared that just did it under the wrong form, but that's the temporary parenting plan. It doesn't provide any RCW 191s for either parent. It frankly doesn't even address decision making. I don't even know how that happened. And then it provides my client a step-up schedule contingent on an investigation with the guardian ad litem. The guardian ad litem was appointed in 2017, however, didn't complete an investigation. Ms. Kelman, I think around that time, moved out of the state. So I think it just kind of absent attorneys being on either case, just kind of sat stale with no movement. So procedurally, it's a strange situation. So.
And I'm sorry, when did you say Commissioner Nelson set the guardianship to?
21st.
So just next week?
I informed them that we would be before the court today, and I'd be getting direction on if I needed to file a immediate restraining order or
not. I've not come across this situation, and frankly, I'm not entirely sure how to proceed or to have you proceed, but that may be the most direct route. So if that's what you feel you need to do, I'm not going to stop you from doing that. It's clearly grandfather is likely doing what he believes is in the best interest given the circumstances, but that does drastically affect your client, and that's he is entitled as biological dad to have rights to this child. So
would the court like me to present the immediate restraining order directly to your honor, since you've obviously been aware of it, and I can present you new information, or do you have just the normal ex parte procedure?
If you want to do it through ex parte and just put a note on it for me, then I'll look for it.
Okay, I appreciate it.
All right, thank you. And then Ms. Gilmore, if you can just remind your client that he needs to respond to the GAL and get that process started as well. All right, thank you.
And it looks like we're still on for just a procedurally while we're before the court. It looks like we're on for a subsequent review in two weeks for the 28th. Do you want to keep that date? Ms. Turnbull, do you think you're going to really get anything completed by then? Or
I think I probably need more time given I haven't heard anything yet.
okay.
All right, how about we strike the 28th? It looks like it was on for visitation and GAL review. Well, one of those we're still working on. Well, both of them we're still working on at this point. So I'll strike the 28th, and it can just be noted back up.
The reason is this
Okay,
might be
thank you.
short because there's a jurisdiction service issue that needs to be resolved before we can go forward on the motion. I'm not sure if Your Honor had a chance to look at Mr. Gilman's attempted services. I'm concerned, at least in the past, service by posting was not considered service in these type of actions. It's good service and evictions and those type of things. But Mr. Gilman did everything he could to get the petitioner served, and they raised this issue in their response. And if we're going to go forward, we'd need an acknowledgement from Mr. Mitchell that he accepts the jurisdiction of the court and is waiving any kind of service issue. Other than that, we would need to strike this, and I would need to chase him around and try to get him served.
Mr. Zandy?
Yeah, no, I don't think we ever raised that issue. I don't think there's a jurisdictional problem at all. This has been pending before the court for some time. My client got the packet of information on his doorstep, brought it to me, and we filed a response. So I'm more than prepared to go forward today, and I think our submissions indicate that. I don't think the service was good under the terms of the rules as it requires personal service or an order to show cause or an order to appear, which a contempt is, but nonetheless, we're waiving any arguments to that.
Okay.
All right. Then with regards to the motion, the response alleges that my client is bringing this in retaliation, and that's absolutely not the case. This is a case where Mr. Mitchell failed to return the child to my client, and that happened on January 6th. And then we brought this motion with regards to child support, failure to pay child support. I appeared in this matter on January 19th, and we filed this motion on January 30th. There was no retaliation involved. We were just bringing a motion for contempt for the violations by Mr. Mitchell. With regards to the contempts, if you take a look at the reports from support enforcement, both I and Mr. Zandy have filed the printouts. The printout filed by Mr. Zandy from the state of Washington indicates that there was a payment of support in August 24th of 2022. And then the next payment was in January 25th of 2023. And then if you look at, we filed the Oregon one in our response to make sure the court was aware of this issue. And on page 5 of the Oregon, they put in the months, even if there's no payment made. Washington doesn't do that. So on page 5 of the report from Oregon, September 20th or September 2022, 0, October 0, November 0, December 0. So we filed this motion for contempt in January after 4 months of no child support. This is a case where Mr. Mitchell was in contempt of child support. During subsequent hearings, Your Honor made a decision with regards to temporary placement and struck his requirement to pay child support. There's no support owed now, but that's not what's before the court. I filed this back in January. It was because my client had gone 4 months and actually had gone the 5th month into January with no payment. Apparently, he made a payment late in January. If you look at the Washington one that shows the dates when it was made, he made a payment in January 25th. The court finally received, or the support enforcement received a payment. And by that time we had prepared this motion, no retaliation, and this is clear contempt. Mr. Mitchell just did not pay child support. There's all sorts of responses about an injury from a couple of years ago and back support and those type of things. We brought this because my client hadn't received support for 4 months, 4.5 months, going into the 5th month, and he's in contempt. It's clearly a contempt. It's not retaliation. My client's entitled to a judgment of back support, and which will give me the ability to try to collect that, or we'll see what goes on in the future with regards to support. But when we filed this, he was in contempt, and I asked the court to enforce its order and find Mr. Mitchell in contempt. Now, the second issue is with regards to returning the child. What happened there was my client, the child wasn't picked up at the bus stop. Now, when I was a kid going to school, and when my kids were going to school, they would get off the bus, and if somebody was there, it was okay. If there was nobody there, they got off the bus anyway. But apparently that has all changed with what's happened in our society with, child kidnappings and various other things. Somebody has to be at the bus stop to collect children. Apparently that's the rule. And what the schools do is, if somebody's not there, they take the child to the bus barn and they call the parents. And this happens on occasion. And it happened on this occasion. Mr. Mitchell decided upon himself, because he was one of the parents called. My client was trying to get in touch with her daycare provider. The daycare provider was held up because of a funeral. So Mr. Mitchell said, I'm going to take her bowling. That was a lie. He ended up not doing that. But my client said, that's fine. When I get off work, I'll pick him up and pick her up. But then he denied that. And then we've submitted text messages in my client's declaration, where my client is telling, per the parenting plan, it's my weekend. I told you could take her bowling. That's fine. And then I want to pick her up. And he says, I'll meet you at 9:30. That's in the morning, the next morning, at the Indy Way, which Indy Way is a diner in the industrial area on Industrial Way in Longview, not their regular meeting place. And these messages go back and forth. And since this, then your honor has required the parties to use the My Family Wizard app, but they were using text message at the time. She tells them in her text message, look, it's my time. I want my daughter. I want to pick her up. I let you take her bowling. She's pleading with him to get her back. And he says, no, the Anyway Diner. And I don't care if the order says that we're supposed to meet in Lexington. And I don't care if it says that it's your time. I'm not returning her. That's contempt. That's contempt, Your Honor. So we're asking Your Honor to enforce the parenting plan that was in place, that there was this issue with regards to picking up at the bus barn, but that's not a reason to take the law into your own hands and do whatever you want to do with the child. You still need to follow court orders unless it's some kind of harm or some kind of major issue. This was just something that happens on time to time, and Mr. Mitchell is unwavering in what he wants is what he's going to get. And so he kept her overnight. My client couldn't pick her up until the next morning. Couldn't pick her up at the regular transport place where that's designated. She was telling them in the text messages, if you read through them, you're in contempt. This is not the court order. And basically he's shrugging his shoulders. So I'm asking Your Honor that when somebody is aware of the court order and is saying, I don't care, I'm going to do it my way and you're going to do it my way, that's contempt. And then, Mr. Mitchell brings up all sorts of stuff about what's happened under the guardian ad litem report and some kind of false reporting to CPS, which we have denied. And now we've got a statement from the person who has supposedly said that my client said, it's hearsay upon hearsay upon hearsay, that ended up in some kind of report in the CPS, but none of that matters. That doesn't matter. It's not, but they're bringing it up because they're going to bring it up in every hearing, every time, he wants to do something. If he wants to violate the order and we object to that, they're going to bring that up and say, well, you're untruthful. You did false reporting. And I ask Your Honor to disregard that. This is very simple. Facts are very simple. He hadn't paid child support for 4.5 months, and he refused to return the child pursuant to the parenting plan, even though my client was begging and pleading and pointing out that he was in contempt. He's nonetheless thumbed his nose at the court's order. And so it's up to Your Honor to say, our orders, we're going to enforce our orders and find him in contempt. And I'd ask that you award attorney's fees for us having to be here today. Thank you.
And thank you, Your Honor. The court's well aware of this case and well aware that I do represent the petitioner, non-moving party to the motion before you today, Jordan Mitchell. I think I'd start by saying that you've got to consider this of the context. This is a case where you heard significant argument a month and a half ago related to the parenting plan. You considered argument about a lot of these back and forth allegations and the veracity of both parties in front of the GAL and how this process is kind of manifested and mushroomed to the point where we are today. So I think in looking at the context of that and my client's concerns and the GAL's concerns and a lot of the arguments that were made back in January pertaining to the change in custody that you eventually entered, I think that gives you a lot of kind of background on where we're at with this motion. We bring that motion, which is on the heels of the GAL recommendation. The court changes custody, and all of a sudden, these long-standing issues pertaining to this contempt motion are brought. To me, that seems very retaliatory, and to my client, that seems very retaliatory. When you're looking at a contempt, that's got to be a willful and intentional disregard for a court order. And my client, that hasn't been, the prima facie case has not been presented to even make that finding. And so we are asking that you deny the motion. I'm going to go through it. I'm going to start with the back end of counsel's arguments and work forward from those. I think if you look at the CPS information, if you look at a lot of the things that were addressed at the time a month and a half ago, those were blanketly denied by Ms. Honey. look at the GAL's context of everything, you'll see that there's been an issue of credibility, a very significant issue of credibility for mom. And I think that dovetails directly into what the arguments are today and what the basis of that motion is. So it is germane. Council said several times a month and a half ago, that's not true. That's not true. We deny that. And the CPS report, again, is just kind of a simple, easy way to prove that what was denied a month and a half ago has largely been confirmed. It goes to the honesty, it goes to the candor of the court, or excuse me, of the parties in front of the court. And unfortunately for Ms. Honey, she has a regular documented pattern of manufacturing certain issues. This is just the latest example. We look at the issue with the school. I think that's the easiest one to decipher. My client details for you. We provided you significant information from Castle Rock, which shows the concern. This is well beyond just an issue where somebody wasn't there to pick up the kid. This happens from time to time. It doesn't happen from time to time. Again, if you look at this in relation to the context of things, you had a GAL report that was issued right after Christmas. You have the concerns voiced from the school, which again is unusual. Typically, the school doesn't reach out to the parties in the GAL like this and say, hey, what's going on with this child? She's showing emotional response to things. This is all leading up to this incident on January 6th, in which child's dropped off at the bus stop at mom's house and nobody's there to pick her up. Again, if you look at the information from the bus garage, we provided you two different documents, one from the bus driver, the other from who I can only imagine is the kind of in charge of the bus garage. Both say the same thing. Child's taken to her bus stop in regular fashion. Nobody's there to pick her up. Bus driver continues to drive, drop the rest of the kids up, circles back, still nobody there. School tries to contact mom, no response. And as a secondary, and again, this kind of goes to the issues that we addressed a month and a half ago, a secondary contact is my client. My client's called, he immediately reaches out to Miss Honey. Again, no response. He drives from, I believe, Rainier at his home all the way to Castle Rock to pick the child up. Child is left in the bus garage from about 3:15 when school lets out to approximately 4:30 when the bus garage says somebody has to pick this child up. We're closing down for the day. My client does that, takes the child back. Again, it's on a Friday night. This is not his weekend. Everybody acknowledges that. What else is he supposed to do? I think a good parent, somebody who's reasonable and prudent, is not going to leave a child this young in a bus garage and say, well, the court order says it's mom's time. I guess she'll figure that out. We wouldn't expect that from a good parent. Now, he was forced into that based on the absenteeism of Miss Honey. Picks the child up. He has a regular Friday night. I think that's, again, detailed in the pleadings. Takes the child bowling. And then he starts getting bombarded with messages from Miss Honey that says, well, essentially, I want a do-over. Thanks for picking her up, but it's my time. Pretty much accommodate me for my inability or unreasonableness as a parent. They're bowling with the family. He says, I'm happy to give the kid back tomorrow. Can we do that? You're, again, impacting our plans as a family that were made prior to anybody knowing that Michaela was going to be at the bus garage for an extended period of time. Exchanges the child the next morning, and here we are. So a contempt is brought. This is one of the first times I can ever remember responding to a contempt in which parent directly, because again of their irresponsibility, places the other in a position that they have to pick up the child and then says, oh, by the way, thanks for doing that, but now you're in contempt because you didn't follow the court order. Well, Miss Honey didn't follow the court order because she didn't have herself or anybody on her behalf there to pick up the child. My client's contacted by some person. He has no idea who she is. Apparently, that's now alleged to be the babysitter. Interesting, this is the first time we ever knew that this person was considered a babysitter. My client had no information on this person, was presented with no type of contacts or anything of the like as to who this person was or would be picking up the child. And now again, kind of to kind of recreate history, Miss Honey attempts to say, well, this was the babysitter and she was at a funeral. One would think, and again, I think it's completely illogical, flies in the face of reason, to assume that this babysitter who was going to pick up the child, and again, pawn the responsibility on this third party, was at a funeral. I would certainly imagine a babysitter would say, I'm not going to be able to pick up the child on Friday because I'll be at a funeral. We don't have any information on that. And again, it's kind of making up the facts after the point in time, again, to suit your needs and suit your position. And that's what Miss Honey tries to do. I'm not sure how the court can find a willful and intentional violation on my client's behalf for that. And again, the allegation alone flies in the face of reason and we think is largely retaliatory. Second to that pertains to the child support. And again, in the initial motion, Miss Honey asks for this judgment. She states that child support has been an issue for some time. My client largely agrees to that. But again, we're charged with the same standard of law. That's a willful and intentional disregard for a court order. And my client spends significant time detailing for you what happened when he first fell behind back in April of 2021. Nearly dies in a motorcycle accident. We detailed for you what the conditions of that were. We gave you a very small sampling of what the medical records were. He broke his back. He damaged his shoulder immensely. He had, at least by my count or recollection, 2 surgeries in the fall. He had no insurance of which to really fall back on to help him stay afloat. As he details for you and is undisputed, in January of that year, he had started to pursue his own business. He was doing well, getting that off the ground. And then 3 months later, he has this accident in which he nearly dies. He's in the hospital for an extended period of time. He has the surgeries, several months later, and doesn't get back to work for nearly a year. That's remarkable in and of its own right, because there was times, and the medical records indicate that nobody thought he was going to be back to work. I've provided you, and this is one where Ms. Blondin was involved at the time. Immediately upon me finding out, I sent her information related to that. We had communications, regular communications on the phone, via email, via letter, and the like, addressing that. We certainly tried to get out in front of that to avoid this very circumstance. We asked for patience because at the time we had no idea how long this was going to be. It was agreed. And again, the communications I think provided by both sides kind of show that. Let's get some resolution to this, but it's hard to get resolution not knowing where you're going to be at in time. And frankly, at that point, not even knowing if my client would survive the spring, given the back fusions, the back injuries, the shoulder, and the head problems. He did. He bounced back. Prior to his second surgery in September, I sent another notice to Ms. Blondin, at which time mediation was discussed, knowing that my client's income was going to be curtailed significantly, which it was. Again, the lines of communication are open. My client goes back to work about March of 2022 and immediately starts paying. His dreams of owning his own business were gone. He goes back to work, starts paying right away, not only the child support amount, but additional amount towards that back support. There's $10,000 that's owed according to the information that we provided you. On reply, we get some statement from Ms. Honey stating, well, this has been an ongoing issue. It hasn't been. My client believes that he was current as of the point of his injury. I think the information presented to you through DCS confirms that. It wasn't until this injury, again, where he's off of work for 11 or 12 months, that he gets behind. We knew that was going to happen. It was by design of the parties back in 2021, this would be resolved or at least addressed at mediation. We could make some decisions from there. What happens on the eve of mediation? Now, we're notified that Ms. Honey has no interest in resolving anything outside of what she wants, and here we are. My client, despite the order that council references that was recently entered, is under no further obligation to pay child support, but he continues to do that. Child support is not only paid in the current amount, but in excess of that towards the back arrearages. He understands that. He's been doing that since before the motion was filed. He's been paying excess child support since he got back to work in March of 2022. Again, the information verifies that. The lapse that he didn't pay over the fall was because he switched jobs from an Oregon company, I believe, to a Washington company. In any event, that's where everything's directly taken out of his checks from DCS. That's where the lull is. And sometimes it takes the administration a few months to catch up on that. That wasn't by design of him. He didn't just simply stop paying. That was just due to the mechanisms that are set in place through the state to have parents pay that obligation. If you notice, we could have filed a stack of pay stubs from him since he's been back. He chose not to do that. But you'll notice that he's been routinely and regularly paying that. I guess I would question if this was an issue. Why was this not addressed? Why was this not raised back in 2021? One can only assume that's because everybody recognized the circumstances. Everybody recognized that this is unfortunately one of the life events that we have no control over, which impacted his ability to comply with the order. It's not because he willfully or intentionally got in a motorcycle wreck on Highway 30 and almost died. It wasn't by design because he willfully or intentionally decided to go through multiple major surgeries. That was certainly not by his design. What was willful and intentional is how we address that after the fact. The communications between the attorney's offices, the information from DCS, and the fact that here we are now almost 2 full years after the fact. And again, right on the heels of a custody transfer, we have a contempt allegation, again, going back to 2021. And again, a simple phone call, a simple communication with DCS that would have shown Ms. Honey that lapse over the fall was probably due in large part, I can only assume, based on a job change for Mr. Mitchell, in which it took the administration time to change over that direct withdrawal from his checks into the child support amount. He's continuing to pay despite the order. We acknowledge he's in arrears. We've acknowledged that from the very beginning. But again, to make a contempt finding, it has to be willful and intentional. That leads me again to my second conclusion, which makes it seem that this is very retaliatory in nature. These parties have a child in common. Now, they need to learn to co-parent. They need to learn to communicate effectively. We were making strides to do that in the summer of 2021. I think the communications back and forth between myself and then Council of London kind of indicates that. Unfortunately, that has gone by the wayside. This does seem largely retaliatory in nature, and we do not think this is certainly based on the fact that my client's currently doing all he can to catch up, a good use of the party's resources, financial or emotional or otherwise. I would also argue it's not the best use of the court system. Again, as this type of matter is easily resolved and certainly, I would argue, does not warrant a contempt motion in this capacity. We're asking you to deny the contempt, that you do consider an award of fees, given, again, the context of this situation and why we're in this matter. And furthermore, and I don't think the point can be stressed enough, if you look at the information, and I opened my comments by talking about the context of this matter. If you look at that information from the Castle Rock School District, whether it be the bus garage, or I believe it was a secretary or a counselor at the school, it's very alarming. Back on January 6th, this was the information that my client was going off of. He had to protect his child. He had a young girl that was at the bus garage without mom being there to pick her up. And in the background of all this is Michaela's emotional wellness, where she's at as a little girl, how she's adapting to things. And the information from the school district, again, is very unique. We don't typically see that absent a subpoena at the time of trial. We have this willingly provided by the Castle Rock School District. And again, what's the term they use? Very concerning. My client as a parent is very concerned, just like the district was, which led to a lot of what's going on today. And frankly, I continue to be very concerned about this type of, again, I would call over litigation, which is not going to do these people any good, let alone this little girl.
Quick question, Mr. Zaney. So your belief, and I'm assuming by way of your client, is that those 3 months this fall, that the Oregon report indicates $0 in payment, is just due to a job switch. There wasn't a lag in jobs, correct?
That's my understanding. And again, once we got the reply, I did reach out to my client a couple of times via email to confirm that. And it's not, unfortunately, it's not confirmed concretely, but he goes, I don't know why I would be behind for those 3 months. He goes, unless that was due to when I switched jobs. So that's the information I have directly from Mr. Mitchell. So that's what's presented. And given the history of this, that's what seems to make the most amount of sense. I can confirm that. I do not want to speak out of turn or misstate anything, but that's the best of my knowledge.
Okay. Anything else, Mr. Anagnostou?
Yes, just briefly, Your Honor. It is 4 months. It was September, October, November, and December of last year. And this is a new position argument from counsel with regards to Mr. Mitchell. If he switched jobs, it's his duty. There's a lot of cases where the father comes in and say, well, I switched jobs and they didn't take it out of my pay, and therefore, I'm not in contempt. No, you're supposed to go to your HR or whoever and make sure that your child support's paid. This is child support, and it's an obligation that you owe every month, and you take care of it. That shows an absolute lackadaisical attitude of Mr. Mitchell with regards to supporting his child. That's our position. And like I said, this is new. He had a position, and I just went ahead and took my whole pay. And yeah, maybe I noticed that it didn't include child support deduction, or maybe I didn't notice, but it doesn't matter. He's responsible for paying child support. And he went 4.5 months, and none of this was retaliatory. We brought this soon after I got involved in this case, within weeks, and prior to your court's order. And it was to get this issue resolved, that he wasn't paying child support. That's that issue. And the bus barn issue, he just basically I understand they went out to the school district and got letters, but the letters basically said just what happened, which is they took her to the bus barn, which is their procedure. And they called the parents and they called the contact information. And he got there first, which was fine with my client. She told him that was fine. He said he wanted to take her bowling. That was fine. And Mr. Zandy said he did take her bowling, but he didn't. At least that's what he notified my client that he didn't, because she was on her way there, and he finally admitted that he hadn't taken her there. And then he kept her overnight in violation of the court's order. And it's just whether this court is going to allow parties to independently say, I'm not going to follow the order.
This is an interesting case. I know that there is a lot of contention in this case. I will say the court's not considering this as a retaliation. The contempt was filed at 9 a.m, the day that custody was altered by the court. So I don't think that this was in reaction to anything that the court ordered. Whether, I know this is a complex and long case, I'm not considering it as a retaliation. So I want that to be very clear. Here's where I'm at. I think that there's been a continued effort by Mr. Mitchell to address child support while he was injured. So, and that's not what Ms. Honey is alleging at this point. Ms. Honey is alleging September through December of 2022. And everything shows nothing was paid during those times. I do see payments starting back up in January. If that's a lag time, I would only have to take Mr. Zandy's word for it. I don't see anything that shows that, oh, those are being processed or those are coming out. Knowingly changing jobs, knowing that that's a direct withdrawal from his paycheck, one would presume that there would be steps for him to take to have to follow up with that. And maybe it's automatic. To be very frank, I'm not exactly sure how that's processed through, or when it's an automatic withdrawal. But very clearly, it probably should have been something on his radar to ensure was still happening. And I don't really have anything that shows that. So is it willful and intentional violation? I think arguably it could be seen as such because he didn't ensure that those payments were being made in the support of his child. So I am going to make a finding of contempt on the child support matter for those 4 months. At this point, I'm not going to award attorney's fees to either party because of this. And I very frankly, if there is something that pops up down the road that shows that those payments were made, but they were just delayed based on the change in jobs, I'd very much like to know about that. As to the second portion, it's a little frustrating that I can't see the timestamps on some of the information that was provided. There's a lot of text messaging back and forth. I don't know how long it took Miss Honey to finally get a hold of Mr. Mitchell after he picked the child up at the bus barn. So I don't know if that was an extended period of time or if it was not. There's clearly a track record of back and forth. Again, arguably, I can see how this would be a violation of the parenting plan, given how Mr. Mitchell reacted. However, it wasn't his parenting time, and he had to go out of his way to ensure that child was safe, pick her up. And I don't think that his then responsibility is to just sit there and wait for Miss Honey for whenever she's available to return the child. If he had plans with his family and was including the child in those plans and then felt it was too late, I frankly, I'm not finding that a willful and intentional violation. So yes, I'm going to strike the section 4. So I'm going to deny that contempt, grant the contempt under section 3. As for the judgment, I mean, the past due child support, I mean, it's already happening. So any concerns with me just leaving that in there? I mean, I don't want, I guess, interest to accrue in a different way than it already is through the garnishment process. So I guess I'm asking for some guidance from counsel. 'Cause I guess I don't want him to be double dipped on interest because there's a judgment and the past due.
And I think because it's being collected on from DCS, that they've automatically got that. So they'll credit whatever payments he's made accordingly. I think a judgment would only potentially complicate that. If that judgment doesn't match the DCS records, I think they're on top of it. I think they have that as referenced by both parties' submissions. I don't think it's necessary. And this is one too, where we're going to have to eventually address child support moving forward based on the change in custody. Which we can do via separate motion. I was hoping to do that today, but I certainly understand the court not wanting to do that. So I think we just omit a judgment and let DCS collect on whatever DCS is calculated. It should put us in the same spot without the confusion.
And I disagree, Your Honor. Child support are judgments as soon as they're not paid. And then what you do is you go to court and ask the court to actually enter a judgment that includes interest. And she's entitled to that. She's entitled to statutory interest on past due child support. Mr. Mitchell can resolve this by paying it. But that's what allows us to do collection, other than the department just waiting for him to pay support and potentially garnishing his tax returns and those type of things. If he gets some people don't. I mean, they owe taxes at the end of the year. So she should have the ability to collect back child support. They are judgments when they're not paid.
Your Honor, Amy Powers for the state of Washington. My video is not working. Our office is involved in this case. It is DCS's preference that you not enter a specific back support judgment. They are in the process of collecting and have kept a running calculation of what is still owed and what is not based on the payments received. So if a judgment is entered, it can cause some calculation problems for DCS.
And I would just remind everybody that this is just all back support at this point. It's whatever he does pay goes to back support, given there's been the change in custody at the first of the year. And there is no further child support obligation that he's to pay her.
Right. Based on Ms. Powers' comments, she confirmed what I was a little bit worried about. I don't want this to disrupt future payments. I don't want this to cause a recalculation. So I'm gonna enter the order of contempt. I'm gonna deny the money judgments and striking the section 4, which was the parenting plan contempt. So I listed the denial in both section 1 and section 8. I'm also striking section 9. Not in the habit to allow for makeup time when frankly, in that situation, I think it was mom's responsibility that dad picked up for. And so it is what it is. So I'll enter that order with those modifications.
Thank you, Your Honor.
All right. Thank you.
And before we log off, are you going to put anything in there under the other section, other paragraph about if in fact it was due to dad's job related or collection related through his employer, that we can, I don't want to revisit the issue, but maybe at the time of finalization upon further order, that might be appropriate.
So what I'm indicating is that the court's willing to reconsider the contempt if the 4 months of non-payment from September 22nd to December 22nd, September 22 to December 22, were due to the change in employment and a processing delay or issue.
Very well. Thank you.
All right. Thank you. I have Mr. Fisher in the booth here again.
Yes,
And
sir.
we have Ms. McLean. Good afternoon.
So we're here.
Go ahead. Sorry.
My notes indicate that we are here on a review from the last time that we were here before the court. That was February 14th. At that time, the court had asked Mr. Fisher to provide contact information to me. I did not receive any new or updated contact information from Mr. Fisher, so all of my subsequent mailings and the like were sent to the last address that we were aware of. In my review, of Odyssey this morning, I didn't see anything that had been filed in response. I've not received anything directly from Mr. Fisher. When we were before the court last, I had filed a default motion ex parte. I have no idea what happened with that, but it didn't end up being processed through ex parte, and court administration was unable to find that. I have noted that up now to be heard on the 28th of March, and I provided a copy of that to Mr. Fisher through mail. I would also note that the last time that we were here, the court ordered that all of the VA benefits were to come to my client for sole use. That's within the temporary order that was filed at paragraph 5A. I can tell the court that since that order was entered, Mr. Fisher has failed to stop his auto payments for his vehicle payment of $270.39, his personal loan of $264, and the T-Mobile cell phone, which varies, and I can't explain to the court why that varies, but the last monthly payment was approximately $170. So that those monies continue to come out of the monies that were awarded by the court, as well as it appears that he continues to use his debit card to consume some of those funds. So at this point, the court, at the time that we were last before you, you entered the temporary order reserving my client's request for some attorney's fees. You entered the guardian ad litem appointment order. You declined at that point to enter the parenting plan or to enter the restraining duty that we had requested. You reserved those for this follow-up, as Mr. Fisher had indicated or represented that he had an appointment with an attorney. I've not received notice of an appearance from any attorney at this juncture. So as far as a review, I guess we would ask that the court consider entering our proposed temporary order parenting plan, as well as the restraining order that we've requested. I would ask that the court reconsider an award of attorney's fees, given the fact that she has continued to have money pulled out of those VA benefits like that, which have reduced what she has available for her and the party's two minor children. My client is a stay-at-home mom. She is the sole home school provider for these children who have their own various disabilities. And so she needs that financial assistance.
All right. So Mr. Fisher, when we were here about a month ago, you indicated you were looking for an attorney.
Yes, Your Honor. I don't have an attorney. In regards to the money being taken out automatically for those loan payments, that's false. I pay those with my Red Canoe debit card, and I can get proof of that from the bank. They don't come out automatically. The VA money stays in the account. I also get survivor benefits of $350 from my mother's Weyerhaeuser retirement that isn't VA benefits. And I use less than that when I have to use a debit card. I went and checked with the T-Mobile account, and she still has an active phone number on there. So they're both being paid as it with the insurance. So I wasn't sure whether I should try to cancel her phone and then pay it separately, because she obviously is still using that phone number and that phone that I pay for. Same with the insurance. If I cancel that or take her off of it, she won't have any insurance for her car. Those are the reasons I have not canceled those automatic payments. I don't know why it's being said that the loan payments for my car or for the personal loan are coming out automatically. It's never been like that, and it doesn't happen. So we can pull bank records to prove that. I paid those out of my account that I get paid for my work. The last time I got paid was the day after we had court. It was a very small amount, so I didn't have very many hours. Since then, I've been paid one time. I did pay, that's when I had to pay the 2 loan payments out of my account, and also pay a portion of the guardian ad litem payment, which leaves me with about $90 till my next payday for gas. So I'm not spending a bunch of money that doesn't belong to me. The survivor benefits for my mother's Weyerhaeuser retirement doesn't belong to her. The VA benefits that she's getting stay in the account and she uses them. Anything else that's been claimed here is false. And we can get a bunch of paperwork. I can pull a bunch of paperwork from the bank and everything like that and whatnot. It's going to take me a little bit of time since my mail situation is fickle at best. I get my mail at my cousin's house and they aren't very organized when it comes to getting it. So I've been getting things a little bit late and having to go there as much as I can and kind of coerce them into finding my mail for me. So I need to find a different situation, maybe get a PO box. Money's kind of tight right now. I don't get paid until Thursday. I also have I'm plan on paying the rest that I called Miss Height today and told her that I plan on paying the rest of that fee that I owe on Thursday is when I get paid. So I had contact with her today and talked to her about that. She said that was fine. So I mean, other than that, I don't have the money to get an attorney yet. And I did not say I had an appointment to find an attorney. I said I'm going to try to find one. It's really hard when you don't have the money to find an attorney to find one. So most attorneys charge, a fee just for a consultation. So, and trying to find one that will take my case, considering how much paperwork I have, claiming things against me. They all seem very hesitant in this area. So I'm having a hard time with that.
All right. And your VA pay is approximately $2,100 a month?
$2,100. So it's about $2,900 a month. Yes. It's there's a VA disability and then combat related special compensation. So it comes out to around $3,000 a month.
Okay.
And I would just ask if the court reviews the temporary family law order that was entered on February 14th of 23. Paragraph 5A, my understanding is that his disability is made up of an ACH benefit pay of $343.96.
That's my mother's survivor benefit. Has nothing to do with my VA pay.
This was my understanding, and this is what's presented in the order. This is our SC payment, which is a civil retirement affiliated, I believe, with his military pay of $917.06 per month, and then the VA payment of $2292.15 for a total of $36.32. And that is what the court had ordered the last time we were here. We had also requested that the court award my client $400 a month in spousal maintenance at paragraph F, which Your Honor denied at the time. Excuse me. So again, we would just simply renew those concerns or those requests. I have no information relative to Mr. Fisher's current pay with his employer. As you can see from the child support calculations that we previously filed, I understood that his pay at that time was approximately $5,200 per month gross from his employment in Portland, which would give him a net of about $8,832 per month, compared to the reality of my client, which is at zero. And that was the basis for our request, as her financial declaration clearly showed that she has a need of about $4,421 per month.
Ms. Height, is the 28th a reasonable time frame, or would maybe a month be better?
Your Honor, I have not received any intake package yet. I did speak with Mr. Fisher earlier today, and he indicated that I would be receiving his tomorrow. He sent it on a special delivery, that I should be getting that tomorrow. I have not received anything yet back from Ms. Fisher. So I think it's probably a little optimistic to think I could get very much done. I hate to ask for delay, but I think it may be unreasonable to expect a whole lot to be done in 2 weeks.
And Mr. Fisher, did you receive a copy of the proposed parenting plan from Ms. McLean?
If it is in the initial multiple pages in the initial packet I was sent, served for the divorce papers, then yes, I had. That's what I have. Was the initial the initial parenting proposal. In that, I haven't seen anything other than that I received before we ever came to court the first time. I think
that is the parenting plan.
It's the same.
Yeah. Then I do.
We're not. Ms. Height doesn't have an early review on March 28th. That's on for default. We're just on for a final a final review in June for Ms. Height.
Okay, I conflated those two things. Thank you for clarifying that. So Ms. Height, phew, I can take a deep breath there. Okay, so a few things. I did on the last time we were in court, 14th, authorize the numbers here. The 91706 and the 229215 would go to Ms. Fisher as support payment, which totals right around $3,000. There is that 343.96 that's included in that. And that sounds, according to Mr. Fisher, that sounds like it has nothing to do with VA benefits and maybe should not have been included in that. When I'm hearing that he has $90 left after his paycheck, I'm a little concerned about that benefit also going to mom.
I don't know where the calculations came from for my pay. I make $27.15 an hour and I'm paid hourly. So I can make quite a bit of money if I get overtime. But like I said, I just came back from an injury. I was in a wheelchair not too long ago. I just got cleared to work on the 9th of February, and they are very hesitant to put me back with a bunch of overtime while I'm still healing from an injury. I can perform my duties, but they're afraid if they push me into 60 hours a week that I might re-injure my foot or have to call out because I'm in pain. So that is affecting my income. I don't get paid salary. It's not the same every time. So
and how many hours are you working currently?
Right around, it depends. A good week is around 36 to 40 hours a week, but some weeks I only work 15 to 20. It depends on how they schedule me.
All right. And are you still getting the additional $5 for their waiver of health insurance for $32.15?
I don't need their health insurance. So yes, $32.15
is
what I get total after that. But that doesn't factor into my overtime either.
Okay.
Again, just for the record, I would point out that he has filed nothing in response. I have no documentation. And if you take the $32.15 at 40 hours a week, that gives him $5,572 per month gross, which is actually, I think, less than what I had in my child support calculations. Yeah, I had $5,200 in my child support calculation. So he's almost $400 a month more gross than what I had calculated.
All right. I'm going to, at this point, I'm not making any changes to that temporary family law order, and I'm still denying additional child support. I think $3,600 a month for family support is sufficient at this point. So I'm going to leave that where it is. As far as the parenting plan, I don't have anything filed. What I'm going to do is I'm going to reserve all the 191s, but I am going to give decision-making to mom. And I'm going to leave section 4 essentially the way it's written, because it outlines those concerns. So Mr. Fisher, the parenting plan that was given to you at the outset of this case is the parenting plan that I'm going to adopt at this point in time. So there's things that you need to do in order to get started with visitation.
Okay.
Working with the guardian ad litem is a big one there. And there's also some evaluations that you need to take part in. I'm not going to, like, this psychological risk evaluation with parental risk components, I think probably is appropriate. But I guess I just want it to be known for the record, and it doesn't necessarily state that in this parenting plan. I'm going to want some input from the GAL before we start visitations or anything like that. I'm not going to require all of these things in place unless there's concerns, because I know I had a case a couple weeks ago where the psychological risk evaluation with parental components was 6.5 months out. And so I guess want it to be known that I'm willing to consider visitation in some form prior to all of that being completed with assistance from the guardian ad litem.
Your Honor, guardian ad litem here, I don't usually ask for more work, but would it be appropriate then to set a review date, an interim review before the end of June?
I guess my position would be is that if Ms. Height has information that she thinks should be addressed, that she can send out a letter to both parties, and we can see about noting that up. I'll just remind the court that there is currently a protection order in place, but we are asking for the restraining order within this case as well. The protection order lapses October 31st of 23.
So Mr. Fisher, I am going to enter this restraining order, and it's not going to have nearly the same kind of parameters on it as the protection order that's currently in place. So all contact at this point needs to be third party, so through Ms. McLean, and the guardian ad litem. You're not to have any contact with them directly. You're not to go to the grounds or enter the home, workplace, vehicle, school grounds, daycare of any of the people or children at this point in time. You're not to harass, stalk, threaten anyone. Stay away more than 500 feet away from the individuals listed. I'm going to just, because we're was a copy of this provided to him as well, Ms. McLean? Okay. So I'm not going to make I'm not going to require service at this point, since he has a copy of it and I'm not making any alterations of it and he's present today.
So you're going to mark the box on page 4?
Yes.
And would you also mark the second box on page 2 under paragraph 4? Please.
I did. Sorry.
That's okay.
All right. All right.
I have my law enforcement sheet on file with the clerk's office.
I have it here and it's attached to that order.
Okay, thank you.
All right. So, Mr. Fisher, thank you for working with the GAL. Continue to do that. Copies of these will be available to you through the clerk's office probably by Thursday, so you can get all the updated information. And it looks as though we're on for the 28th for a default. So I'm assuming you've been notified of that date and time, and hopefully you can find an attorney to help you out.
I have a question, real quick
Sure.
question. So when it comes to the automatic payments for the shared insurance and phone we have, so is it okay for me to just go ahead and take her off those and then change my payment to my new bank account so it doesn't come out of that account anymore?
The court has indicated there's to be no changes to the insurances. My client needs to remain on the insurances.
But and you, Mr. Fisher, you're saying the insurance is paid out of the Red Canoe. Is that where the VA benefits go?
It's one of the things taken out. And I understand that. That was my point with the phone too. She still has an active phone through the phone T-Mobile that was claimed that I'm having taken out. That has both of our phones on it, and it comes out of the account. She's using that phone service also, and that's why I haven't done anything to cancel it. So
okay, but does it come out of the account that your VA benefits are in, or your separate account?
It does.
Can you just? I'm going to ask that at this point. Actually, I'm going to allow the phone bill to come out of that account as of right now, and that can be just noted in the future if there's some concern there. And I know it sounds like it varies. If it becomes an issue, then I'm happy to reconsider and have that either the parties have separate plans and change that, or to have that be something that's paid for in a different manner. But at this point, since it's something that's utilized by both parties, that can just come out of that account.
It wouldn't be an issue for me to get my phone number switched to a different account and leave that for her, so it's not a problem for her. Also, I'm flexible with that type of thing. I can take care of that if that's what would help. So.
Do you want to have her removed from that plan?
No, what I'm saying is I can.
No, I'm not. Hold on, Mr. Fisher. I'm talking to Ms. McLean for a second.
I think my client is on here. If she could just give us a nod of her head if she's okay with that.
Yes, Your Honor, I'd like to be taken off the phone plan.
Okay, so then Mr. Fisher, if you want to drop that line and then change the payment to your primary account, not the VA account, then.
Yes, Your Honor, I'll take care of that.
Okay. All right, good luck, and I guess see you in 2 weeks.
She'll remain on.
Excuse me?
Turn my video off. So, okay. So, I just want to make sure that I understood. So he's going to remove himself from the existing T-Mobile account and leave my client on the T-Mobile account. He will access his own account and make payment on his own cell phone.
So my understanding, and I guess maybe I misunderstood Ms. Fisher, was that he could just drop her from his account. She would get her own cell phone and take care of that separately. He would keep the account and transfer the payment to his other account.
Yes,
that was my understanding.
Okay, just for my clarification, I guess I need to know if my client's phone has been paid off. If that was her intention.
Yes, I checked that on the status of that recently, and her phone is 100% paid off.
So, Alina, is that acceptable? You'll get your own plan then?
Yes.
Okay, thank you.
Okay. All right. Thank you, Mr. Fisher. Thank you, Ms. Fisher. Good luck.
So this comes on my client's presentation of proposed final orders. There was an original default order that was entered against Mr. Naselrod, excuse me, back on December 7th of 2020. And in the intervening 2.5 years, Mr. Naselrod has taken no action to have that default set aside. My client wishes to be divorced and has submitted her proposed final orders with a proof of the basis for those final orders. I do note that I did receive a response to the petition from Mr. Naselrod. It appears that his only complaints are that the allocation do not include his credit cards, and he doesn't believe that the home is valued at $346,000, but he doesn't provide any supporting documentation as to what his credit cards were at the time of separation. I can tell the court, at least through online review, as far as the values of the home, we took the average, which is that 346 value. We have provided him, as I indicated, notice of this presentation. So we filed the request for or the presentation of the proposed final orders that are consistent with my client's petition and the allocation of the assets and debts. In reviewing Mr. Naselrod's response to the petition, and again, at this point, there's been no motion to set aside the order of default. But in reviewing that, the only things that he complains about are that his credit cards are not included in the final orders. Of course, in the petition, there was no allocation of credit card debt for him. And so that hasn't been objected to prior to that default being entered. And that the value of the home is basically the average of, am I still cutting out?
Nope.
Okay, is basically the average of values online. He hasn't provided anything contrary to that. And so our position is that the final orders should be entered as proposed.
All right, Mr. Naselrod?
Yeah, Your Honor, I was...
My only objection would be is that, again, technically a default has been entered. And so technically he should not be heard, but I just make that objection on the record.
Okay.
Your Honor, me and Ms. Naselrod believe that there was a time frame of when I got served papers the first time, that if I didn't respond to them, they would just go away because she was living here the whole entire time. I just recently got these papers in the mail. It's postmarked for February 21st, but I received it March 2nd, which really hasn't given me any time to get a lawyer. I don't have an issue paying for a lawyer. It's just finding one at this point right now. And I didn't provide any documentation with the notice of response to the Noel because I really didn't have any time. I mean, I'm more than willing to get the house appraised, all of that.
My client is entitled to finalization in this matter. I have provided appropriate notice under the court rules as well as our local court rules for presentation of final orders. I did provide him notice because the default was entered more than a year ago, and that's pursuant to a court rule. And so we believe that we are properly before the court.
All right, we are in a situation where, frankly, an order for a default was entered December 7th, 2020. At any point after then, Ms. Naselrod could have filed for final dissolution, and really that's where we're at. You got notice of the presentation of final orders based on that default. And you did respond to those, but never responded to anything else in the petition or the motion over the course of the 6 months before this case basically went dead for a couple years. I understand if that may be based on you folks trying to work it out again, whatever the situation is. But by rule, I don't have a motion to void the default in front of me, and I'm going to enter the orders as presented. Obviously, if there's some major discrepancy in any of these orders that you're concerned about, Mr. Naselrod, and you do find an attorney, then I guess there's potentially opportunities for you to pursue this once you have counsel. But I'm going to enter the orders as presented.
And just so Mr. Naselrod is aware, I will provide him with a conformed copy of the orders, as well as I will have my client sign a quitclaim deed and the real estate excise tax affidavit. I will send him those originals, and it will be his responsibility to file those with the auditor and the, I'm appearing on behalf of the petitioner, Colleen Gilman.
Christine Dow on behalf of the respondent, Tristan Gilman.
And we are here on my client's request to modify the temporary orders, modify the temporary parenting plan, to reappoint Ms. Day as the guardian ad litem in this case, and to provide for an order for the, excuse me, for the parties to file their 2022 taxes separately, and for my client to be able to claim Freya as a dependent. And then we have the second motion, which is the contempt motion before the court. So do you have a preference on which I address first?
No.
Okay, so I'll just start with a motion to amend. So we are asking the court to amend the current temporary parenting plan that was entered back on March 22 of 22. Ms. Day did complete her initial investigation, filed her report on October 26th of 22, which expressed concerns about Mr. Gilman's video game addiction and the resulting neglect of Freya during his residential time. Unfortunately, Mr. Gilman continues to acknowledge playing video games, although trying to minimize the negative impact on Freya during his residential time. My client and her mother and her sister tell you that there have been times when Freya has been unable to wake her father up during her residential time with him. And again, this is due to him apparently having sleeping issues, playing video games all night or the like. But this is a young girl who's just getting ready to turn 6 years old, or I think maybe she has turned 6 now during the pending of this action. And she is not of sufficient age or maturity to be able to meet her own needs. Freya has exhibited anxiety since this original parenting plan has been entered, which has resulted in physical ramifications where she will actually physically throw up prior to having to go on visits with her dad. Mr. Gilman has acknowledged that Freya has thrown up during his residential time, but again, he tries to downplay the results of that. Freya has been observed hiding behind furniture in order to avoid having to go with her father on visitation. And you can see from the declarations where my client is continuing to try and support Freya in going on those visits. Mr. Gilman has talked to her on the front porch, trying to ease that transition, but there is clearly something seriously affecting Freya's relationship with her father and her desire to be there. The other concern is that Mr. Gilman is living in this shed. There is no running water or a toilet. We've not seen any documentation that indicates that this facility has been given an occupancy permit by the city for someone to reside in it as an appropriate housing facility. Freya has to go into his sister's home in order to access running water and facilities. And it simply is not appropriate. And then we get to the most recent disclosure where Mr. Gilman, as part of his treatment, of which my client was unaware that he had gone to treatment in December of 2022, following a suicidal ideation where he had a plan, a means, and a motive, and acknowledged placing a loaded firearm in his mouth in December. So a little over 4 months ago now, he did this and disclosed this to my client earlier this year. He doesn't dispute that he placed a loaded gun in his mouth. He provides absolutely no assurances that he doesn't continue to have access to firearms, ammunition, or other weapons that could be used in harming himself. And ultimately, we're asking the court to restrain Mr. Gilman from having access to or possession of any firearms, ammunition, or weapons during his residential time. He should also be, in light of the reply information, he should also be prohibited from purchasing weapons for Freya or engaging her in any type of education, such as firearms education and the like. That should be, if not a joint decision, that should be my client's sole decision, given the issues that are raised in this case. We are asking that the court enter an affirmative order prohibiting Mr. Gilman from accessing gaming, electronics, or other late night activities during his residential time. If those are things that are keeping him up and then making him sleep during the day and inaccessible to his daughter, that is a huge concern. We are also concerned by the fact that Mr. Gilman refuses to allow Freya to contact her mother, her aunt, or her grandmother, both or all of whom she has a very close and connected relationship during Mr. Gilman's residential time. Mr. Gilman doesn't deny that he's refused Freya contact with her family, who clearly are her source of comfort when she's in distress. If you review the current temporary order parenting plan at paragraph 14I, you will note that there is a provision that the child is allowed telephone access to a parent without interference from another parent. And arguably, he has violated that provision. Historically, Freya has taken her own iPad on visitation, but if she doesn't have access to Wi-Fi, then that interferes with her ability to communicate with her mom, her aunt, and her grandmother. But clearly, Mr. Gilman has Wi-Fi access if he's able to continue to promote his online gaming. So we're asking, in light of all of these concerns, they are very fresh. I did today receive this information about the suggestion that Mr. Gilman participated in a program through the Wounded Warrior Project. I have no idea what the parameters of that treatment were. I don't know what their recommendations were. I don't know the information that he provided to them. And I don't know what is supposedly taking place by these follow-up Zoom meetings. It appears that that information may have been forwarded to his attorney yesterday, since there was an email dated yesterday that was submitted. So I'm concerned about the fact that we have an individual who clearly had a depressive or post-traumatic stressor issue that resulted in an attempt at suicide. We have a child who is of vulnerable age, and we already have a finding from a guardian ad litem of neglect by this parent. So we're asking the court to adopt our amended temporary order parenting plan that provides for 4-hour visits on first, third, and fifth Saturdays, supervised by his sister or brother-in-law who are residing in the residence at the property where he is staying. We're asking that the court reappoint Ms. Day so that we can get some further input from her, as clearly this is a significant change since she last entered her guardian ad litem report. And then the other issue that we had requested in the motion is that, and to be quite honest, I don't recall that Mr. Gilman even addressed this issue, was the filing of the 2022 tax return. We are asking that my client be allowed to file married and separate, claiming Freya as a dependent. When we get into the contempt motion, you will see that Mr. Gilman has made no child support payments in the year of 2022, even though his child support obligation was to commence February 1 of 2022. And ultimately, my client has provided 100% of this child's financial support since their separation. So she should be allowed to claim the child on her taxes for 2022, and then we can continue to reserve future years.
As far as the temporary family law order is concerned and the proposals in that order, my client doesn't object to Ms. Gilman's request to re-engage a guardian ad litem, but his only income is VA disability. And so we would ask that his portion be county pay if the court is going to grant Ms. Gilman's request. As far as the taxes are concerned, he has no objection to Ms. Gilman claiming the child tax benefits for 2022. He's acknowledged that he had some issues with child support for 2022, so he doesn't have any objection to that. As to the amended proposed parenting plan, which is the big one here, my client doesn't neglect his parental duties towards their child. He takes care of her needs when she's with him. The fact that she has anxiety issues is something that he recognizes, and he works on those with her. He's said that in his declarations. The fact that he encourages her to play with her cousins, or that he might play video games with her, or do video chats with a friend of theirs with her, that doesn't mean he's not taking care of her. As he said in his declaration, he paid attention to what the guardian ad litem said about his gaming and about being up late at night. What he has done about his mental health issues has had an impact on that. He doesn't have the same difficulty sleeping that he did. As to those mental health issues, he's been forthcoming about post-traumatic stress issues related to his military service. Successful mental health treatment basically comes down to finding a therapist or a program that works for you individually. Mr. Gilman has found a program and a group that's specifically oriented to veterans that works for him. He's continuing to participate in the Wounded Warriors Support Program. We can provide additional information to the court and to Ms. McLean about the specifics of that program. But as he said in one of his declarations, he spent an entire week with that group in December. This all kind of came to a head late last year, and he found this group. He spent a week with them. He is participating in the follow-ups, and he's doing much better. He's only been participating since December, so ordering a mental health evaluation at this point is likely to tell us what we already know. He suffers from PTSD. His situation is improving with participation in that program. So we're asking the court not to order an additional evaluation at this time, and to recognize that he hit a very serious low at the end of last year. It interfered with a lot of things in his life throughout 2022. He was able to step up on his own without a court order and find a resource that works for him. The request to limit his access to weapons during his residential time, the way it's worded is unrealistic. I mean, how are we going to implement that? There's no restraining order. There's no demonstrated grounds for this provision, aside from the fact that he did have a plan for suicide before he entered into this mental health treatment program. The same thing goes for the way the request is worded for gaming, use of electronics, or late night activities during his residential time. How's that going to be defined for dad and the child? Does that mean no television? Does that mean no video chats with friends? Dad said in his one of his declarations that he has a very good friend. The child enjoys sitting on his lap and chatting with his friend over Zoom. Does this mean no game playing at all? No playing with the child? No playing on his own? It's not clear in the way it's phrased. He is aware of the issue with game playing. He's paid, as I said, close attention to what the guardian ad litem had to say, and that's an issue he's addressing. But the way this request is being made, they don't get to watch television at night either. It can't reasonably be implemented the way that it's being proposed. And again, as I started to say, excuse me, Ms. Gilman's declarations are referencing issues from last year, and they were early last year. These are things that Mr. Gilman is working on. There have been some changes made. So this all kind of leads up to their request to reduce parenting time and to require supervision. There's no reason for that. There are no grounds for that here. The current parenting plan has weekend parenting time. There's no demonstrated danger to the child. Her needs are being met when she's with Mr. Gilman to the best of his resources. He's making deliberate, organized efforts to spend one-on-one time with her, but also to encourage her to play with other kids, to play with her cousins, to be relaxed around other people. He's aware that she has stress issues. He does his best to talk to her, to soothe her, to have her calm down when she's with him. These issues are, as we understand it, they're being addressed in her counseling. That's something that he doesn't have any control over. All he can do is talk to her, settle her down when she's with him. Ms. Gilman isn't showing any reasonable grounds to reduce his time or show that supervised parenting time is necessary. If a better schedule for the child to communicate with her mother when she's with her dad is necessary, that's not a problem. This issue about Wi-Fi and access to Wi-Fi is a little bit sketchy where they live, and it applies to gaming as well as video calls, as well as, you know, whatever the child uses or dad uses. It's part of their location there. And I will also, again, mention, which my client has mentioned in his declarations, essentially he lives with his sister. They put together a tiny house structure that is maybe 10 feet away from the house. That was so that they would have some privacy from each other. It's big enough that he can use it as a bedroom, that he can spend his time in there. There's space for him and for Freya. They step out the door and step into the house to use the bathroom and to use the kitchen. He stores food out there, snack food, things that don't need cooking, but they use the house as freely as though they actually physically spend all their time living in the house. A lot of these things can be addressed without reducing Mr. Gilman's parenting time or requiring supervised visitation. And, you know, I'll point out that if we're asking for the guardian ad litem to be re-engaged, it makes more sense to hear from the GAL before we make any significant changes to the parenting plan. So that's what we're asking the court to do. He's agreed to a couple of things that need to be dealt with child support. But if the guardian ad litem is going to come back, there's really there's no point in making changes at this point in time if the GAL is going to make other recommendations. So we're asking that that be denied.
I'm going to sign the amended temporary order, family law order. I am going to order a reappointment of the GAL. And what I've indicated, the only change I made to this is that in under section 10, I'm going to have it.
I guess if I could just, I'm just looking at this. I didn't realize this before, but previously the county paid 100% of the prior GAL fee.
And that's what I'm indicating on here. I'm 100% county paid, but that we can review that in the future if.
Okay.
But at this point, I think county pay is appropriate. So.
And I think that the amount, your Honor probably knows better than I do, is it $14.85? That would need to be changed in. I think that was just adopted, wasn't it?
It was. Would the parties be okay with maybe a May 23rd interim GAL review? And then leaving the August date for the final review?
Sure.
Yes.
Okay.
And I guess my only comments were that the guardian ad litem independently did make a finding or recommended a finding for the court of neglect by Mr. Gilman. I've seen nothing that has shown any efforts or what supposedly he's done as it relates to his gaming activities. Our concern, of course, is that he's minimizing that, and we still have the child's physical reactions as far as throwing up due to anxiety and whatnot when it comes time to go on visits with dad?
And Your Honor, we don't have any evidence showing that he has not taken the guardian ad litem's words to heart, beyond his sworn statement that he has. And this issue about the child throwing up from anxiety, there's no indication that, she doesn't do that elsewhere as well. That's a common sort of a reaction for a high stress kid. It may not just be going to dad's.
Of course, I didn't see Mr. Gilman denying that in his reply declaration.
He doesn't have enough information to say when and where else that might happen.
Right. Here's where I'm at. I think this is a difficult situation. I'm assuming once Miss Gilman was made aware of the struggles that Mr. Gilman was having, it terrified her in probably a lot of different ways, not only for the behalf of Mr. Gilman, but on behalf of their child. And I think the knee-jerk reaction is to, okay, we need to circle the wagons and figure out how to insulate our child as much as possible from any negative activities, reactions, what have you, based on those concerns. It's completely and totally reasonable. And I would agree that there are some definite concerns that have been outlined by mother in this case. We are in a situation where it looks like the parenting plan that was ordered in March really wasn't changed by the final GAL order. For a change now based on the circumstances that occurred over winter. So most notably December 2022. I'm always concerned for the safety of all the parties, and I have to be very cognizant of the best interest of the child in this case. It appears as though Mr. Gilman is making steps to try to address the issues that he has. At this point in time, I'm wanting that interim report from the GAL. And frankly, if she gets it done sooner and we can come back sooner, great. But at this point, I'm not inclined to change the parenting plan. I'm inclined to add some conditions to the parenting plan. I do have some concerns with the amount of time being used to engage in gaming or other activities. If dad's on a better schedule now based on the treatment that he's starting to get through the Wounded Warrior Project, and please correct me if I'm wrong, that he just started engaging that in this December. Is that correct?
Yes, he did a
okay.
week long in December, and now he's doing a twice a month Zoom meeting with his group.
I'm going to ask dad to have a mental health evaluation. And if that was done as part of this treatment through the Wounded Warrior Project, great. That needs to be provided to Miss McLean and the guardian ad litem. If not, then I'm going to order that he obtain a mental health evaluation, follow any recommended treatment. So if that's above and beyond what he's already doing, then that's what it is. I'm going to order that during his time that there isn't, I guess I'm just going to put a lights out kind of condition at 9 p.m. And that's for gaming issues. If they go to a movie and it ends at 9:30, I'm not super concerned about that, but I don't want up all night TV in the background or gaming systems in the background while child's trying to sleep. So let's have a 9 p.m. kind of parameter around that. If there's some gaming or FaceTiming or whatever that they do together, I'm not concerned with that. I do want to have
about independent gaming.
If it's like something that they're playing together, or if they're FaceTiming somebody together, I don't have any problems with that.
But if he engages independently, you do.
Yeah.
In other words, if he games independently.
I think he can refrain from doing that when he has his daughter at this point.
Okay. Not after 9 o'clock. That's quiet time, sleep time.
9 o'clock, yeah, after 9 o'clock is quiet time. And then I want him to engage with his daughter, not with a video game when his daughter's there, unless they're playing something together.
Okay.
And I mean, just kind of going along 4A2, I think is appropriate. And whether that's, they're just, I don't know if there's a safe in the home, that any kind of firearms, ammunitions, or other weapons can be secured in the home with sister and brother-in-law. That's probably a good idea, period, but especially during any time with the child. And then I want to address the concerns that, and it sounds like he's more than willing to accommodate the communication. So there should be free communication. If the child's having some concerns, wants to call mom, wants to call another family member and just have a conversation with them, she should be free to do that. There shouldn't be any withholding from that. If it's a situation where it's after 9 p.m. and she's having some kind of anxiety or trouble and wants to just call mom, that should be allowed. So I want there to be free communication between child and family when she's with dad. And that would also go for when child's with mom and wants to reach out to dad, she should be able to do that as well. I guess I should have said, and if I didn't already, the mental health evaluation, I want the GAL to be able to weigh in on that, since since she has a history with the case already. So I would want her to be able to weigh in on that, or have access to that evaluator to provide any information she feels necessary.
So the court's not including the mother in that?
I'm fine with both of them having input. That's fine.
Okay.
And then those evaluations should be provided as soon as possible to the opposing party.
Your Honor, can I just clarify something here? The
Sure.
way that is worded is an evaluation with a parental risk component. Getting in to see those folks is, my recent experience is months at a time. So if we could just word that so that it's a standard mental health evaluation, take a look at what's going on with Wounded Warriors, see how my client is doing, with input from the GAL and from mom. I think that would move us forward.
And I'm not doing the parental risk component at this point. I do know that can be difficult, and that may be something down the line. But at this point, I just want a mental health evaluation with the GAL and Ms. Gilman's opportunities for input.
Thank you.
And then Mr. Gilman should comply with any recommended treatment. And I don't know, I guess, Ms. Dow, if in your conversations with Mr. Gilmore, you're under the impression that there was an evaluation done through the Wounded Warrior treatment program or whatever it is.
Your Honor, I am not really clear about that. I've had dealings with other vets who have worked with the Wounded Warrior Project, and if I recall correctly, it varies the way they approach these things, but I can certainly find out.
Okay. I guess I would want there to be an opportunity for the GAL and even Ms. Gilman to have an opportunity to weigh in on any treatment that he's getting through that program, if they're willing to allow that. And I understand there may be some different parameters with them as there would be with a private practitioner. Any other changes at this point with the parenting plan? So I'm happy to, I don't know if the parties want to craft a new kind of order and I'll sign that ex parte, or we can set it for presentation. But at this point, I'm not gonna completely change the parenting plan. I recognize the concerns, but I also recognize both parents. He doesn't get a lot of time as it is. And it's probably, frankly, I think it's probably best for everybody's mental health to keep involved in the child's life as much as they can, and hopefully work through this process within those parameters.
Will the court consider adding at paragraph 5A, my client's concerns about making sure that any enrollment in hunter safety or other weapon use classes for the child would be joint decision making as well.
Yes, that can, yeah, I'll put that as part of a change.
Okay, and I can get that prepared. I'm unfortunately home this week. So I will see what I can get done later this week to Ms. Dow. Unless you want to schedule, if you want to schedule a presentation, I'd say I'd like to set it 2 weeks.
So 21st for presentation on that.
Your Honor, can I step in for just a moment on the firearm issue?
Your Honor, he has counsel. I would ask that the court not consider that.
Yeah, I'm happy, Mr. Gilman, to put you in a breakout room so you can speak with Ms. Dow, but you are represented in this case. And if you'd like me to do that, I'm happy to do that.
Yes, would that be possible?
Sure. Hold on 1 second.
Your Honor, we're back. Okay, so Mr. Gilman's father passed away a couple of weeks ago, and he is currently in possession of all of his firearms. His sister and brother-in-law have more firearms than he does, and they are locked in a safe. He has a safe that he can put all of the handguns in, but the long guns are a bit of a problem. And with Washington law, transferring those guns to somebody else's possession is going to be kind of a problem. We can certainly secure the handguns. I'm just not sure what to say about the long guns. I mean, we'd have to file for a special permit to transfer them to somebody else's possession.
I think that he can store them at minimal expense with Gators guns. I think it's a minimal annual expense in order to store those at Gators guns for safekeeping.
Okay, and is that somebody here in town?
Yeah, Kelso, just under the big bridge next to the CJAC office.
Okay, well, we can certainly look into that with the understanding that that's something that the court is ordering him to do. I can't commit to him having those guns there because we haven't talked to Gators guns yet, but he can lock up the handguns, and we will contact Gators guns to see about storing the other guns.
So, and I guess just for clarification, the way that so he's not to possess or access. So is he able to lock those up in his sister and brother-in-law's gun safe that he doesn't have access to?
He would have to take his separate locking safe and put it in the house. And let me just clarify, are we talking about access to guns during his parenting time, which is what you put in your motion, or are we talking about no access to guns whatsoever? I mean, that's moving a little further down the road.
My order is just during parenting time, excuse me. So I guess without knowing the number of firearms that we're actually referring to here and what kind of difficulty this is, long story short, I don't want him or the child to have easy access to firearms when they're together. And so if that is in a safe in the home that he has access to, when the child's not there, that's fine. I'm not ordering that he never have firearms, period. It's just they need to be locked up. And if that's in the tiny house on the property, as long as they're in a safe, that's fine. As long as they're locked up and the child doesn't have access to them either.
We'll figure it out.
All right. Okay. And then the contempt.
Yes, on the motion for contempt, we are asking that the court enter a finding of contempt. The child support order required Mr. Gilman to pay child support effective February 1 of 2022. He has made one payment. The second payment that he made was just recently. And while WSSR did transfer that to my client, she also received notice that she was to return it because there was insufficient funds in order to actually provide for that payment. Apparently, in further communications with WSSR, they said that they would go after him for the insufficient payment. But at this point, as of February 1 of 22 through February 10 of 23, he owes her $6,205.56 in delinquent child support, as well as $421.10 in interest. We would argue that Mr. Gilman clearly could have written a check and sent that to WSSR, but instead he chose simply not to pay. It's not as if he was setting those monies aside for the child. And so again, he clearly has discretionary spending, and he chose to spend that on his own needs rather than on his child. We're asking that the court enter an order that he's to pay no less than $250 towards the arrears. We're asking for $750 in attorney's fees and $100 in sanctions to be paid within 60 days. Obviously, I was present earlier when the court heard additional argument from Ms. Powers relative to judgments. And technically, I mean, I understand the concern that that can potentially cause havoc with WSSR, but given the fact that we have arguably one actual payment, one insufficient payment, I don't see where that really is going to run afoul of their computations. We do these all the time. And the other thing is that, again, the statute does recognize that an unpaid child support payment automatically reduces to judgment and starts bearing 12% interest. WSSR will not calculate interest, and they won't collect that interest unless it's been reduced to judgment. So if the court, based on my, excuse me, on my proposed order, if you are going to strike the principal amount, which I, again, would respectfully argue that it is an appropriate amount, we've provided the calculation for that, that if you do that, we would ask that you indicate that that's reserved for determination by WSSR, but keep the interest judgment in there because, again, they will not do that independently, and they will not collect it unless this court has reduced that to judgment.
Ms. Dow?
So, Your Honor, as my client said in the declaration that he filed, he understands that he's behind on his child support. As far as the finding for willful and intentional violation of the order, we're asking the court to take into account the mental health issues he was struggling with last year. Once he started participating in the Wounded Warriors Counseling Program in December, he was able to get himself organized, start making payments in January of this year, which is before the motion for contempt was filed. He's way behind, but he has already been talking with WSSR about making at least $100 additional payment every month in order to catch up on his arrears. That is based on the communications that I've seen and that I've had with them. Whether or not he's going to be able to make more is a question that we have to explore. He's got some other bills that he needs to pay too, plus the standard child support that he's paying. So we are asking the court to at least take under consideration what his mental health issues were last year, and the fact that once he engaged with this program, he got his act together and started paying child support. He does not know what the problem was with the bank account that he's designated to WSSR for taking funds out of. It's possible that he didn't transfer enough in there. It's possible he transferred a large sum in there and there wasn't enough left for the child support payment. That's something that we're figuring out. So we're asking that the court not reduce this to judgment and give him a chance to figure this out with WSSR.
Just briefly in response, he was employed at the time that this order was entered. I'm not sure why or when he lost his job or if he quit his job, but certainly he had more financial resources available to him. The court has determined that his child support obligation is $517.13 a month, and he's now asking that you enter an order that at $100 in repayment, which means that'd be 5 years and 2 months for him to repay child support that's accrued in a year. Again, my client has the complete financial responsibility for raising this child at this juncture. And he has increased VA benefits, which we haven't seen at this juncture, but have been advised of that. And he certainly has the ability to provide those payments.
And Your Honor, he's already agreed that.
Your Honor, I guess counsel's already made her argument. I think the way it goes is I get the last bite at the apple.
Your Honor, I'd just like to point out that tax returns and refunds are a standard pool for arrears in child support to dip into. He's already agreed that she should claim the child in 2022. If he's got outstanding child support and he has a tax refund coming for any employment that he pursues, she's going to get that. So it's not going to be 5 years.
Well, there's no indication that he is going to get a refund, and his VA disability is all non-taxable.
All right, here's what I'm going to do. I'm going to make a finding of contempt on child support. This was 9, 10, 11 months in the making. I understand he made some efforts. Probably if I was supposed to be paying $517 a month and noticed that it wasn't going somewhere, I think that's that's a quarter of his income that's alleged at this point in time. So I would probably know whether that was here or gone. So I'm going to make a finding of contempt. I'm not going to impose a civil penalty or lawyer's fees at this point in time. I will enter the judgment amount because it's much less convoluted than the last case, but I am going to indicate that the actual amount will be reserved for determination by WSSR. I'm not going to require anything more than $100, so no less than $100 per month towards arrears. So that would be a $617.13 payment minimum a month moving forward. If you can pay more, great. If there's a chunk of a tax return that comes his way, great. I made the same changes under section 1, under section 8, under section 11. I've made the change under 11B to $100 instead of $250, and I'm striking section C under 11, and I've signed off on that order.
Is the court willing to reserve fees?
For this contempt, no, not.
All right.
And then, so the order appointing and the temporary family law order will go with this contempt order, and then we'll hopefully have the next one next week.
Okay, thank you.
All right.
Thank you, Your Honor.
Thank you all. Good luck.